typically the first questions that we ask. What medications are you on? What medical history do you have? And do you have any allergies?
As you were nailing, I want you to take us to that moment. As you're nailing, trying to help Mr. O'Keefe, did you have a chance at any point to look up?
I did.
And when you looked up when you were trying to help Mr. O'Keefe, can you tell us who you saw?
I saw a middle-aged middle-aged female with blood on her face. And real quick, as I was in the process of providing ventilations, I said, do you know this person?
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
Sir, could you point out that person that you looked up and saw?
In between Mr. Jackson or next to Mr. Jackson.
I see. And when you looked up and saw that person and asked about any background, what did she say to you?
I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
Could you stop, please? Do you see the red lights on the left?
Yes, sir.
Is that when you believe that you first arrived?
Yes, sir.
And that note says 6:11:05. Could you continue, please, Ms. Gilman? Please watch to the left. Stop, please. Is that when you first arrived and walk over to help John O'Keefe?
Yes, sir, that's me.
I'll note that the timestamp is 6:11:21. Okay. Continue, please. Stop, please. Did you see firefighter Flamati come after you?
Yes, sir.
Continue, please. Stop, please. Okay. Do you see the defendant in that screen?
Yes, sir.
Do you see her moving from right to left towards you?
Sustained is to the form.
Okay. What direction do you see her running in that screen from right to left?
She's running towards where the three of us are grouped.
Okay. Please continue. Stop, please. Is it at that time the defendant said to you that she hit him?
Yes, sir.
And you remember that?
I do.
Okay.
Was knelt down providing chest compressions at the same time you were knelt down providing airway support for Mr. O'Keefe, correct?
I had also said that at some point,
That's a
firefighter
yes or no
Flamati
question.
Objection.
So I'm going to let the witness answer the question.
had transferred CPR to firefighter Kelly. Firefighter Kelly did take over compressions at one point.
Okay. That's not my question.
Okay.
My question is an easy one. Did you say that when Miss Reed walked over to you and you had this dialogue with her, she made that statement, that firefighter Flamati was on his knees providing chest compressions at the same time you were knelt down providing airway support?
Yes, sir.
Okay.
Katie McLaughlin made the statement that she said, I hit him four different times and in front of a police officer. But at no time during the first trial or as of now in this trial has any police officer said that they heard Karen Reed say that. And Alan Jackson went one step further when he was crossing her, Katie McLaughlin. Ed said, if a police officer heard Karen Reed said, I hit him, why didn't I see my client in handcuffs? He asked her that specifically.
perjury or instances, I'd say.
That was defendant Karen Reed's takeaway from a full day of Jen McCabe's testimony.
It's just more of the same. Inconsistencies, every statement's different. Under oath, not under oath, with the cops are all wrong.
McCabe told prosecutors that after 6 a.m., after finding John O'Keefe's body in the snow,
she started yelling and pulling on me to Google hypothermia and Google how long it takes for somebody, to die in the cold.
Had you ever attempted to search about hypothermia any time before that moment, that morning?
No.
Or that day?
No.
Karen, did you tell Jen to make that Google search that morning at 6:23?
I did not tell Jen to make a Google search. I certainly didn't tell her to make the one at 2:27 either.
That is another example of you coordinating information with other witnesses in this case, correct?
No, that is not correct.
There were a few tense moments.
As we're fighting over silly words, whether I said as I got out of the car, were you there?
Words matter. They matter a lot.
From last year's testimony.
But overall, a very different, more subdued Jen McCabe on the stand this trial compared to last.
Was there any discussion about crafting your testimony?
That was good. That was good. Here's the testimony from the first trial. This is her at the first trial. And then they showed this picture from her today.
Was there any discussion about crafting your testimony in any way to suggest a softer approach?
No.
It's not reasonable, okay? You got a dead body in the front lawn of a cop's house. You know it's a cop's house, right? You don't go in and clear the house. You, law enforcement, you don't go in to see how, what's going on inside the house, if the occupants of the house are okay, or are they dead too? And they're
how about if the perpetrator is still on scene? You have a Boston police cop, John O'Keefe, dead on the front lawn of a Boston cop's home.
You also testified in your direct examination, staying with Ms. Roberts for just a second, about a timeline that you and Ms. Roberts put together, correct?
Yes.
That's another example of the two of you talking about your own perceptions and comparing and contrasting those perceptions and putting it down on paper, correct?
No,
Yes or no?
it's a no. Can I explain or no?
I'm sure Mr. Brennan will have follow-up questions.
You can't explain, lady.
After you gave that answer to those law enforcement officers at that separate law enforcement agency, they asked you, was there anyone else that you contacted in that 10-minute period before we got a chance to talk to you?
Mm-hmm.
And your answer was no, correct?
Correct.
And that was a lie, correct?
It wasn't a lie, no.
Was it true? Was it the truth or a lie?
It wasn't a lie.
Okay, so it was the truth. You had not spoken to any other person between the time they contacted you telephonically and you said, I need 10 minutes, and then they came in the door. During that part of time, you didn't talk to anybody else or contact anybody else other than Matt McCabe, Carrie. Now you're testifying that is a true statement.
I can't answer that yes or no.
And Ed, why can't she answer that yes or no?
because she spoke to 5 people. It is a lie. Or technically it's a lie. Okay. Yeah, it's a lie. And for those of you who said AJ didn't impeach her, he just did. He impeached her.
He totally.
Now the jury, all the jurors know she lied to the FBI, although they never used the FBI, the other law enforcement agency. Then another golden spot of this for me was, because he goes through this and he says, don't worry, I'll help you out. Because nowhere in that grand jury testimony do you ever say that Karen said, I hit him.
Right.
Okay, it's not there. These are the answers that you gave, right? And she's playing games, okay? And again, the district attorney knows if he prepped her or not. And if he allowed her to perjure herself, he has now committed a crime. Okay, subornation of perjury. Okay, there's no way that he allowed her to get on that stand without doing trial prep for her.
And it's not just one butt dial, correct?
There could be multiple, yes.
7 butt dials in the course of 19 minutes, less than 20 minutes, correct?
That evening, I wasn't paying attention to butt dials or calls. I was going back and forth, listening to music, being with family. So if I inadvertently called his phone, I did.
Not inadvertently called him once. 7 times, correct? According to you.
According to the record.
And we only know about these calls because you're looking at an extraction of John O'Keefe's phone, correct?
Correct, but I also turned over my phone, so you could have gotten all of that off of my phone as well.
And you're well aware that an extraction was done on your phone and not one of those butt dials appears on your phone extraction, correct?
Objection.
Are you aware of that?
I am not aware of that.
Next question.
How could she not be aware of it? It came out in the last trial. Okay, so again, she's lying, and she deleted all of those phone calls.
And Judge Bev, when the kitchen, it's getting hot in the kitchen, she says, next question.
And how does Judge Bev not know this? Because she sat on the freaking bench the last trial.
Mm-hmm.
Okay, it's not as if this is new.
Was anything that he said at the end there about documenting the evidence and not taking photos correct?
No, it was not in the standard of forensics. When you conduct a crime scene investigation, you have to document where each piece of evidence comes from. It has to be shown on a sketch. You have to take measurements. He didn't do any of that, nor did he call the crime scene investigators who are trained to do just that to do it. Okay.
They were found in the general area. All of them were found in the general area and not documented.
And so where's the integrity of the investigation?
When Alan Jackson, and kudos to Alan Jackson, there's not many defense attorneys that I actually love. I actually love the way he goes at his cross-examinations, the way he goes at the witnesses. He is like a pit bull, and he never let up. He was relentless with exposing Sergeant Buchanan for the non-investigator that he is. He's not an investigator.
And no reasonable person who knows the smallest aspects of the crime scene standards can say what they did was reasonable or can come up with some excuse to overlook all the flaws in their investigation and all the flaws in their crime scene techniques. He took all those plastic pieces and put them in packages together. They're supposed to be individually packaged. Okay, there is not one lick of documentation, yet he says there's integrity in this investigation. There's no integrity. There is no investigation.
Right.
Okay?
And
look at the size of those pieces. How did you miss that in all those other searches before?
Yeah. And let's not even get into reports being filed 100, 200, 300, 400, and 500 days later.
Some of the important factors in here about what transpired that night at that house, that it was involving the love triangle and what happened at the bar that night. Okay. And today, as opposed to the last trial, you got all of these text messages that came in, because the last trial, those you didn't have nearly the amount of text messages. He made that sergeant read those text messages.
Wow.
So that everybody could fully understand what was happening here between Karen and Higgins. Yeah. And that was masterful. And then right after that, he jumps into the video inside the bar.
And it responded, "Do you like me?" I said, "Yes," from jump. Defendant said, "When was jump?" I said, "First time I saw you."
"Do you like me?" "Yes," from jump. "When was jump?"
"Did you try those Smirnoff screwdrivers?" I stopped at the Hilly for one last night. I said, "Haha, how did you get my digits?" Defendant responded, "The Melissa and Lito show." I said, "Haha, I thought you creeped John's phone." I said, "Haha," again. Defendant responded, "No way. I was the last person in Greater Canton who didn't have your number. I think even Kerry has it." I responded, "What?" with a bunch of question marks. I said, "I just don't give my personal number out to anyone."
"Haha, I knew she did. Sorry you felt neglected. Haha. So no dice on the Smirnoff?" "I have not tried it. Saw it in the store the other day and thought of you. I laughed out loud. Don't give Carrie my digits. Thought of me and everyone's grandfather. I won't give your digits to anyone. You don't like Carrie? I have no issues with Carrie. Just don't want her having my jack. Saving you as Karen, screwdriver, or weed whacker. Need to think about it a little.
Yes, I saw that he was trying to make it like it was a conversation back and forth. Whereas when Higgins was asked to do it, he just was straight down the board.
Thank you. Sergeant, at some point during the course of your investigation, did you learn that the Albert family had gotten rid of the dog named Chloe?
We learned that they no longer cared for the dog. I don't know if get rid of is accurate.
Well, they don't have it anymore, right?
Yes.
Okay, so what would you call it?
Giving it up for adoption, I guess? I don't know. I'm not a pet owner.
What if they didn't give it up for adoption?
I'm sorry?
What if they didn't give it up for adoption?
Rehomed, I guess?
Okay. So it's no longer with him, right?
Correct. They no longer own the dog.
Okay, so they got rid of it. It's like you get rid of a car, right? Right?
You can get rid of a car, yeah.
Okay. And you can get rid of a dog. That's all I'm asking.
Yes, you can get rid of a dog, yes.
Okay.
Used that exact verbiage that the dog was rehomed, but it took a lot for Alan Jackson to get that out of him. Right. And it took a lot for Alan Jackson to get anything out of Sergeant Buchanan. He was very combative on his answers. He was talking about, I don't know if this paper is certified. He was challenging Alan Jackson's authenticity of all of the documents that he brought forward in the court.
I'm not sure when they were interviewed. I don't have a memory of instructing him to go interview them.
May I approach, Your Honor?
Yes.
Thank you.
Take a look at that document and tell me if you... Why don't you just tell me whether or not that refreshes your recollection as to communications you had with Michael Proctor specifically. Thank you, Sergeant. Does that refresh your recollection as to a communication that you had with Michael Proctor?
Unfortunately, it does not. I will take the document at face value. I do not have a memory of having these communications, but I will take the document if it's authentic and it is true and accurate that it took place. But I do not have a memory of sending these text messages.
Yes.
Also, my name's misspelled in there. Is that from the extraction, or where is that from?
Couldn't tell you. Wasn't me.
Appreciate it. Thank you.
I can't take credit for that. If your memory is not refreshed about that particular communication, do you remember in general communicating with Michael Proctor about interviewing Ricky D'Antona and Heather Maxson?
I do not know. I'm sorry.
Would that have been something that you would have found important relatively early on in the investigation? Now, these are eyewitnesses. Let's get them interviewed.
Yes, it is important to interview anyone that's an eyewitness. Sometimes it takes longer because... Are you listening? I'm sorry.
Thanks.
You asked the question. I just wanted to answer.
I know the answers to my own questions. Go ahead. I may have misspoken. Sergeant, take a look at that. I thought that was a report from somebody else. It's a report from you, actually. Tell me if that refreshes your recollection as to when Ricky D'Antona was actually interviewed.
Yes, this report, authored by me, was states that on Saturday, September 2nd, he was interviewed.
What year?
2023.
So that would have been a year and a half later, correct?
Yes.
Do you believe that's a timely report, or rather a timely interview for an eyewitness, the gravity of which is described in the report?
Again, perfect ideal world scenario, it would be quicker.
Now, prior to holding the rank of sergeant with the Needham Police Department, what did you do before that at the Needham Police?
I was a detective for 8 years.
Now, at some point on January 16th of 2024, did you have occasion to collect buccal swabs or samples in relation to this case?
I did.
And before I get to that, just briefly, as far as with your work as a Needham police detective and or sergeant, you had no involvement with any investigation either by the Canton police or the state police in relation to any incident in the town of Canton, correct?
Correct.
Were you ever asked to do any buccal swabs of Chief Berkowitz of the Canton Police Department?
I'll allow that.
No.
Were you ever asked to do any buccal swabs of Detective Kevin Albert of the Canton Police Department?
No.
Were you ever asked to do any buccal swabs of Lieutenant Brian Tully of the Massachusetts State Police?
No.
You know, how many crime scenes have you and I been to, Ron, where quick-thinking police officers, in order to safeguard evidence like that blood drop, went and found clean containers to put over the top of items of evidence like that, whether it's ballistics or in this case blood,
Right.
to protect it from being damaged or altered any further than it was because of inclement weather and the people at the scene.
I've
Okay.
done it numerous times as a patrol cop, and I did it numerous times as a detective. You have to adapt to the climates that you serve. These guys are protecting and serving in Canton, Massachusetts. They get tough winters, and there is no excuse. There is no excuse, no matter who it is, that you failed to preserve a crime scene or evidence. And if you don't know what you're doing, you don't wing it. And this guy right here winged it. It's clear and apparent.
In supervisory hierarchy here, that boss that lived across the street was higher than this lieutenant, and that Lieutenant Gallagher reports to him. Okay,
Yeah.
so he answers to him. He should have came out and took charge. Did he? I mean, he's the lieutenant of the detectives. All right.
He didn't do it. He didn't do it. And that's what makes this all super shady.
How deep was the snow covering that frozen ground?
Approximately 4 inches at that time.
When you want to look around the area, did you consider using a rake or a shovel?
I did.
And did you?
I did not.
Why didn't you use a shovel at that point?
I was afraid I would miss something or possibly break something.
And
Unbelievable.
anytime you want me to stop it, let me know.
Unbelievable. That's just wrong. Okay. There's a process to examining snow, and it involves, guess what? A clean shovel and sifting and melting. He doesn't know jack shit about forensics. Okay. So he shouldn't be making these decisions anyhow. He should have called the goddamn crime scene unit. All right. Maybe their initial call to the Massachusetts State Police did not give them the correct information for them to respond.
Right.
Okay.
In an instance like this, if you are not capable of it, because there's people in the chat that are saying, well, they did the best that they could. No.
Not even close.
The best thing that they could have done is backed out, secured the crime scene, because nothing was going anywhere. It would have just got filled up with snow, and then the right way you could have got, like you said last year, a big industrial thick tent, and then you use heat lamps to melt the snow, and now you have all your evidence. There it is.
Wait, there's so many, there are protocols for this. I mean, so you don't have to make it up. It's already there. They just didn't know them, and they apparently don't have the equipment to do it. But you would think in the Northeast, in New England, it snows a lot. They would know these procedures.
Use your personal vehicle. Different than typical?
Yes.
And why would you use a personal vehicle instead of a police cruiser?
It was larger. It was four-wheel drive. It was the only way I probably would have got there to the scene.
After you received the call about a situation, tell us what you did.
Loaded up the car with a tent, and I drove to the Canton Police Department, and I got some winter gear from the office, and I got on the radio and advised Sergeant Sean Good, who was at the scene on Fairview, that all officers were held to further notice.
What does that mean?
They weren't going to be going home at their end of the shift until they were relieved by another supervisor.
Why did you take a tent with you?
Because of the snow. The way the call was described to me was a person possibly not breathing. And if it was an unattended death, I wanted to be able to cover the person.
Why?
Respect.
When you got to the Canton Police Department, did you learn anything from any of your colleagues while at the police department?
The only one colleague at the police department at that time was Officer Kelly Dever.
Yes.
Does that refresh your recollection that it was August 9th, 2023?
Yes.
Okay. I want to direct your attention, Officer Dever, to January 28th, 2022. Where were you working? What was your duty assignment on that day, January 28th, moving into January 29th?
Well, 3.5 years later, I remember I was on patrol. I don't remember anything further about this night.
So not professional, and showing the bias and showing that blue wall of silence. I mean, it is so clear and so evident with her testimony that she flipped that script because she was called in to the police commissioner's office and told, if you don't withdraw this and retract it, your career is going to be a tough one. They're not going to say, I'm firing you, because they can't, but she will be walking a beat on the Brighton Beach boardwalk for the rest of her career.
Aren't there a lot of missing videos from the Sally Port?
Oh, yeah.
Okay. Where is it?
Definitely remember is they said that they would charge me with perjury.
A claim Jackson refuted.
Did you also say on that phone call, I know you're going to tear me a new one because I'm changing my testimony?
Changing, no, but you're trying to do that.
Alan Jackson pressed her about being called into the Boston Police Commissioner's office about this case, following it up with this question.
Have you ever heard of something called the blue wall of silence? Objection.
Sustained.
My entire job revolves around what I say on the stand right now. If I was to lie, I lose my job. I lose everything.
If you agreed with what you said in August 2023 on this witness stand, you would be implicating two officers, fellow officers, as having been in the Sally Port, weirdly, for a wildly long time with the SUV, implicating not one, but two fellow officers. Correct?
If I was to lie, then yes.
What you thought?
This just plays into the totality of all that the defense has been saying in all of their cross-examinations during the prosecution cases. The sloppy police work, zero to none chain of custody, the improper protocols for forensic evidence, the improper handling of the evidence, improper handling of witnesses, not interviewing people for years later, not doing reports for years later. This all missing videos, this all falls in. I mean, if you look at the totality of all of what transpired here, okay, and then having seen what these same players have done in other investigations, then you got to ask yourself, why did they deviate so much in this investigation? Okay, and I mean, it doesn't take a rocket scientist, okay, or a bogus engineer, dances with dummies, okay, to figure this out.
Where the most important points were, that Sally Port is a very important part of security inside Station House. And if you're working the 911 switchboard and a lieutenant tells you to go and work it, he's not going to send somebody that is incompetent. So for her to say that after 3 years, it's really not clear to her, that is, I wish I had a bullshit button.
A bullshit? A bullshit? A bullshit.
There are forensic standards. Okay, first of all, they failed criminal investigation 101. Okay, just from the initial response, our patrol officers would have came there, looked at John O'Keefe's body, looked at his injuries, immediately called the detective squad and saying, hey, we don't know how this guy got here. He's got what appears to be blunt force trauma injuries to his head. He's got all kinds of wounds on his arm, and he is fighting for his life right now. So we classify this as a possible assault, victim likely to die, at which point the detectives go out there and they notify the crime scene unit and we respond.
The glass that you showed the jury yesterday, when you showed it to us yesterday, did it look any differently than when you recovered it from the ground where you were looking that morning?
No.
Did you have any information that that glass came from inside Fairview Road?
No.
Do you know where that glass came from?
I have no personal knowledge where that glass came from.
This guy They didn't know what they were doing here. They didn't articulate what was at the scene properly to the state police, who had better resources and capabilities than they did. Nowhere in these books will you find forensic red Solo cups, forensic Stop and Shop bags, and forensic leaf blowers. And I should send that lieutenant, but he's retired now, so he doesn't need it.
Thank God he's retired. Thank God he's retired.
A copy of my book on how to manage crime scenes, because he don't know jack shit.
You follow where the evidence leads you, period. Amen.
Absolutely.
Did you consider the scene itself where there may have been a debris field?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
Okay, what did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember if I saw anything else.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you would find on a cell phone?
No.
Did you look at any of the data evidence from the defendant's Lexus?
No, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter. It did not hit him, so it was not relevant to my opinion. By looking at the body, I could tell that there was no evidence of impact with a vehicle. So whether the vehicle was going slow or fast is not relevant.
And so when you look at the pathology, the autopsy of his brain, you're looking at a subarachnoid hemorrhage, you're looking at a subdural hemorrhage, and it's a classic blunt trauma laceration.
It's caused by Mr. O'Keefe falling backwards on the ground.
My opinion is that that's what caused his whole injury.
So you have doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable? You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
You said that when Mr. O'Keefe first incurred his injury, you think that he was unconscious?
Yes, I think that the severity of the impact made him immediately unconscious.
So if hypothetically Mr. O'Keefe incurred his injury sometime around 12:32, is it your opinion that he never moved again until he was moved physically by somebody else?
Well, I don't know the exact time that he got the injury on the back of the head, but after that time, he could not carry out any purposeful activity.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as an apple. Do you see, have you looked at x-rays before?
I have, yes.
Have you interpreted x-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at x-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at x-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
You didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
It's amazing what he can remember and what he can't remember.
So, A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible.
Holy shit. So he's actually typing on the keyboard and looking down at his laptop.
He's got a paper there too. I don't know if it's the keyboard or the paper. He's flipping pages.
if you look at his right arm here, he's typing on the laptop, and he is looking down at this laptop. Now,
regardless of what he's doing, either typing or looking at the paper, he shouldn't be doing any of this. He was already warned to stop this.
You just got
Dr. Welch, I have to ask you not to refer to
I'm trying to.
See, she saw him. She's elevated, so she sees him.
Let me close it. Sorry, I was trying to answer his question.
I'm going to ask you to close the top.
People emailing me while I'm testifying live, or I have my Zoom open.
Mr. Alessi's speaking to him. He's not even looking at him. He's not even looking at the jury. He's looking down at that device that nobody else is allowed to bring up on the stand. No other witnesses were able to bring a freaking laptop. This guy was controlling PowerPoint.
Yeah, they got to stop that too. None of this more PowerPoint testimony. That's bullshit.
That's probably a good idea.
You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
But the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks? 2 weeks?
I don't actually know without looking at the documents.
Unfrequently gives forensics a total black eye. I'm so disgusted with him. Okay, and the nonsense that he's pulling. You know, this isn't science. This isn't even engineering. I don't know what this guy is doing. He's doing a dog and pony show. Okay, when you don't got nothing, you dazzle him with bullshit.
I'm thinking of the jury here. They had to have been like, what in God's name is going on? Why doesn't this guy answer a question? What are they trying to hide that he can't outright answer a question? And Alessi, he was asking questions very precisely. He was trying to be precise in the questions he was asking him, but he kept making it difficult. Ed, let me see what you got.
9 pages worth of notes from this asshole's testimony.
Fewer than 24 hours ago, the doctor testified about dressing like O'Keefe, buying a replica of Reed's car, and doing a simulation, something he called the blue paint test.
If you used a crash test dummy, correct? You could have done that.
If you use the right crash test dummy, and then to set up the test, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
Well, he said this numerous times today. Well, guess what? If you don't have enough information to conduct these tests, then you also don't have enough information to give an opinion, a definitive opinion, as you did yesterday, on how this happened. All right, so knock the bullshit off.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm.
Do you recognize what's depicted on this?
That's the x-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record, medical records or in these records?
It was a series of the x-rays, yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Dr. Retrial, you were asked a series of questions about a hat, about some shards, about a drinking glass, about a drinking straw.
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't of that impact.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And
or so.
how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
What's different about this photo, sir?
That taillight is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection.
What's different about that taillight?
Can you see that? So this area was intact. This is what I saw was missing here.
In terms of the light that strictly goes toward the front, you have marking lights, plow lights, and headlights, correct?
Correct.
When all of those lights are on, how bright is it in front of your truck?
Extremely bright, almost as if I had a spotlight.
Once you got into that truck in those early morning hours, how far could you see in front of your truck?
As far as my eyes would let me see.
You're now driving up Fairview Road, and 34 Fairview's on your right. How much of the front lawn of 34 Fairview could you see?
I could see all the way to the front door.
What obstructions were there at the time when you first passed the Alberts residence?
None.
How much of the time that you're plowing are you scanning the road?
All the time.
Now, as you're passing 34 Fairview, could you see the area of the flagpole at 2:45 in the morning, sir?
Yes.
What was on the ground on the Alberts lawn at that point in the area of the flagpole?
Nothing.
Did you see a 6'1", 216-pound man lying on that lawn?
No.
Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a half-centimeter abrasion, and then we have the laceration and scuff on the left side, and then the skull fracture. It's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the half-centimeter. It's not a bruise. It's a half-centimeter abrasions, about an eighth of an inch.
Listen, you keep saying the physics and the physics. Do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
Can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir? How'd it break that night?
How did? Oh, I don't know. There's no evidence of how it broke.
Crash reconstruction expert Andrew Rentschler says the state's expert eyeballed evidence, didn't take measurements, and failed to explain how the taillight would have shattered. He says John O'Keefe's arm injuries are not consistent with a taillight strike and that his skull fractures couldn't have been caused by Karen Reed's SUV.
What the defense's expert is doing is going through and kind of going through the injuries on his own. And not only is he saying that the injuries don't line up with what John O'Keefe had, but he's talking about what injuries John O'Keefe didn't have, what they didn't see on John O'Keefe that they would expect to if the car crash had gone on the way that prosecutors say that it had.
Karen, was there confusion? Did you guys rest or not rest or what happened?
How do you feel
ready for closing?
I'm ready. Yeah, I'm ready. Why 90 minutes? What can we expect to hear?
all the facts, all the truth, everything that went wrong with their case.
Sorry, what do you make of the prosecution not calling any rebuttals?
They don't have any analysis and they don't have any facts to present through Dr. Welcher, so they're done.
And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal clear. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor. When it comes to the Bowden, and I would incorporate, and I know there's no request for instruction, third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden? You don't think the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated in the case law on evidence. And obviously, the court is well aware there's a specific instruction that no matter how the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only a Bowden or a third-party culprit instruction.
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials that packed evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it.
I think what Mr. Lally was saying, that you asked questions but weren't given answers, and so I think that's what was said. I'm going to Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. Tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. Correct. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue, and failed to act on it. But it's strictly for that purpose, okay?
Jurors have been told to report early to the Karen Reed trial. The judge wants to get closing arguments and final instructions in so that the jury can begin its deliberations tomorrow. The jurors have been in court for 8 weeks now, sitting through 31 days of testimony delivered by 49 witnesses. WBZ's Christina Rex, who's been following this trial from day one, shows us what we can expect tomorrow.
The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over.
Outside court, a crowd of people is growing. They believe Reed is innocent in the death of her Boston police officer boyfriend. Jury will start deliberating Friday afternoon after closing arguments.
I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long.
They'll be in a room with all this evidence, books of reports, John O'Keefe's clothing, and the taillight itself. Karen Reed is focused on the verdict slips and jury instructions, so that unlike in her first trial, jurors understand that they can come forward with a split decision to prevent another mistrial.